Owning assets jointly with one or more children or other heirs is a common estate planning shortcut. But like many shortcuts, it can produce unintended and costly consequences, such as unnecessary taxes, creditor claims, and loss of control. One or more properly drafted trusts can avoid each of these problems without the need for probate. Hi, I'm Antoinette Bone, estate planning, probate, elder law, and guardianship attorney in the Dallas-Fort Worth Metroplex, and today we're going to talk about the perils of jointly owned property. There are two potential advantages to joint ownership: convenience and probate avoidance. If you hold title to property with a child as joint tenants with right of survivorship, when you die, the property is transferred to your child automatically. You don't need a trust or other estate planning vehicles, and it's not necessary to go through probate for the person to receive the asset. Joint ownership offers simplicity. I get it. But it can also create a number of problems, especially if you add someone as a co-tenant instead of a joint tenant with right of survivorship, including: first, you may pay unnecessary taxes. Adding a child's name to the title may be considered an immediate taxable gift of 1/2 of the property's value. And when you die, the property's value then will be included in your taxable estate, although any gift tax paid with the original transfer would be allowed as an offset. Second, your property may be subject to creditor claims. I'm not talking about your creditors. I'm talking about your co-owner's creditors. Joint ownership exposes the jointly owned property to claims by co-owner's creditors or former spouses. Third, there will be a loss of control. Your co-owner may be able to dispose of certain property without your consent or prevent you from selling or borrowing against certain property. In the case of bank accounts, legally, they can take out as much of the cash in the account as they choose since they are an owner. This might not be what you had in mind. And finally, there are the unintended consequences. If your co-owner predeceases you, his or her share of the property may pass according to his or her estate plan or the laws of intestate succession. If you hold the property as co-tenants instead of joint tenants with the right of survivorship, for instance, you'll generally have no say in the ultimate disposition of that portion of the property. One or more properly drafted trusts can avoid each of these problems without the need for probate. I'm Antoinette Bone, estate planning, probate, elder law, and guardianship attorney in the Dallas-Fort Worth Metroplex. Call my office today to get started on your estate plan to help you avoid this red flag. 817-462-5454. If you found this content useful and would like to see more like it, please subscribe to my page, like this video, and don't forget to tell your family and friends. Thanks for watching, and I'll see you next time.